MSNBC legal analyst Danny Cevallos, who is an expertise at defense witness, more of on the defense side of things. Mr. Cevallos, good to see you, sir.
Good to see you, too.
All right, so let's go through could it be used? How would you use it? So let's do the basic thing. Is a person's tweet the words in a person's tweet as definitive to you in a court of law as a recording?
Yes, they can be admitted. The first problem is you have to authenticate the evidence. In other words, you have to demonstrate that it is what it purports to be. And when you get into social media, that can sometimes be an issue. If I try to introduce a computer printout of a web page or a tweet, then I'm going to at least need some evidence, some testimony to say that, hey, that comes from my account, or some metadata, or some computer evidence showing that it came from my computer or my iPhone. But if you can authenticate the tweet, there's no reason why tweets are not statements like any others that might be against your interest, that get introduced against you when used in court. But let's go way back before any trial. There's no question that Mueller is looking at these tweets and already has reviewed probably all of them and does so on an ongoing basis, because if nothing else, whether or not they're ultimately admissible, they are a glimpse into the mind of the person making those statements, the president.
And it almost helps you with a timeline, right? If he's tweeting, then you know that, oh, maybe I ought to look at that day. Who did he meet with? Things like that. All right, so let's go through a few of these tweets, and let me get your take on this. So, May 12, 2017, Trump tweet. James Comey better hope that there are no tapes of our conversations before he starts leaking to the press. This is literally days after Comey is fired.
Right.
How would you handle this evidence? And is this evidence of obstruction? How would it be used as evidence of obstruction?
If you look at that tweet and then the tweet that preceded it about Comey before Comey was fired, that first one talked about how Comey or Hillary was aided by Comey. It was somewhat benign, but then now you get into this the nastier tweet after Comey is terminated, and you start putting all of these together to show that, number one, Trump is probably putting out some kind of implicit threat. Comey better hope there are no tapes. It's even more so if there are no tapes. What if it's just a bald threat for Comey to keep it quiet? If it was something to induce Comey to remain silent, especially in the face of any duty to speak, like, for example, in front of a grand jury or Congress, then these are the kinds of things that Mueller will find very interesting, irrespective of whether or not they're eventually way down the road sought to be introduced at a trial.
Could you remember there was one really controversial tweet that did border on whether it seemed to be that he did, and all of a sudden his lawyer said, no, I wrote it.
Yes, maybe my favorite tweet of the year. Yes, of course. John Dowd. Yes.
Right. So I guess my question is, why couldn't the president's lawyers at any point in time just make that claim? If not the lawyer wrote it, Dan Scavino wrote it, it wasn't the president. Can they establish that it's happened enough times that you actually could create enough reasonable doubt about whether he authors his own tweets?
The reason that particular tweet, which supposedly was authored by John Dowd, and he said so days afterwards, the reason that is such a dangerous practice is that in certain circumstances, the words of someone's attorney can be imputed to the client. So that is a risk right there. But secondly, it tests the bounds of credibility if John Dowd authored this tweet. First, it contained misspelling. Second, it contained what would be a very damaging statement as to criminal liability because it included the words Michael Flynn lied to the vice president and also the FBI, which, if true, suggests that President Trump was aware that Flynn was lying to the FBI, which is a crime. So whether it's authored by Trump or his lawyers, it makes the lawyers look just galactically incompetent if they were authoring tweets that suggest criminal activity.
So you don't think it will be difficult for the prosecution to authenticate this. But let me ask you another question. You heard Rudy Giuliani said if you're going to obstruct justice, you wouldn't do it so publicly. I mean, is there a part of the code that I'm unaware of that says obstruction of justice has to be done in secret?
You have to obstruct intentionally, but you don't have to obstruct in secret behind closed doors. Practically speaking, that's the way obstruction usually happens.
So why isn't just constantly saying Mueller's probe is a witch hunt? Mueller's probe is a witch hunt. At what point does that become obstruction if you're the sitting president of the United States and chief law enforcement officer and, oh, by the way, have the authority potentially to questionable constitutional authority about firing him?
As a criminal defense attorney, I think a creative prosecutor could take what you just said and make that obstruction. But then they have a decision beyond that. Beyond just saying this fits into a theory of criminal liability, they have to ask themselves, can I prove this beyond a reasonable doubt to a jury in my particular jurisdiction? So, yes, you can any creative prosecutor could take those facts and say that they constitute obstruction because especially they constitute some form of intimidation. But it has to fit within the 7 or 8 or so statutes that address obstruction. You need an existing investigation or proceeding. As long as you have those elements, then you might have a crime.
I know it's possible to obstruct justice without the crime actually having happened, but let me ask you, how much weaker is an obstruction case if you can't prove the central crime?
As a criminal defense attorney, I would say you have a point there. But there are so many high-profile prosecutions and then low-profile prosecutions that we never hear about of Section 1001, and that's making false statements to investigators. Martha Stewart is a famous example. So the DOJ and the U.S. attorneys have no qualms at all about charging someone with a crime. In fact, I have to give them credit. They have to. They have to enforce this law. They have to prevent, as a matter of policy, people coming in for informal interviews and just lying to investigators. So it is true that in the United States, there may be no underlying crime, but if you choose to come in and speak to investigators and obstruct justice by fabricating evidence or lying, then that is a separate crime, even if there is no underlying crime. And it probably has to be that way in order for the DOJ to do business.
Well, obviously, this trial, if it ever happened, would be a political trial, since it's not a normal court of law trial. And so the politics of this might matter as well. But the legal aspect you have covered quite well. Danny Cevallos, much appreciated, sir. Hello, YouTubers. If you're watching this, it means you've checked out our channel, so thank you. Now do me a favor, subscribe by clicking on that button down there. Click on any of the videos to watch the latest interviews and highlights from MTP Daily and MSNBC. You can get more Meet the Press content every morning in the First Read newsletter. If you're tired of content that you don't know anything about where it came from, you don't have to have that problem with us. NBC News, MSNBC, MTP, and the Meet the Press mindset right here for you on YouTube. Subscribe now.